Hi, my name is Christopher Carr. I'm an attorney here in Las Vegas, Nevada. I practice primarily in the area of family law here in Clark County. I actually practice in several areas of the law, but my firm focuses mostly on family law. I'm creating a series of videos here to acquaint people with family law in Clark County and the family court system. So this video is devoted to just giving you a general overview of the court system and how your case progresses through it. Please bear in mind that this video is just for general informational purposes only. Nothing in the video should be construed as legal advice. Nothing really substitutes for sitting down with an attorney and talking about the specific facts of your case and how the law applies in your situation. So I encourage you to do that. The court system here in Clark County is comprised of 20 family court judges. They're labeled Department A through Department T, and they handle all types of family law matters: divorces, custody disputes, annulments, legal separations, name changes, guardianships, everything in the family law realm. So, how do you get your case in there? Well, most cases you file what's called a complaint for divorce. There is a specific exception to that. If you have an uncontested divorce and you and your spouse agree on everything, and I mean 100% of the issues, you can prepare what's called a joint petition. You both sign off on that, and you deliver that and the supporting documents that are required to the judge with a decree of divorce, and the judge should sign off on the decree, and you'll be divorced without ever setting foot into a courtroom. Now, that's only available for divorces when the parties agree on everything. All other cases are opened with the family court through what's called a complaint. That can be a complaint for custody, a complaint for divorce, a complaint for annulment, a complaint for legal separation, what have you. You file your complaint at the clerk's office at the family court. You'll also need to bring what's called a summons with you that you prepare, and the district court clerk will issue the summons. You then need to serve the summons and the complaint on the other party. You could use a private professional process server to do the work for you, or you could use a friend, family member, or coworker. Any adult over the age of 18 that is a resident of Clark County can do the service for you. If you go that route, however, you should be aware that that person needs to do the service correctly, and they also need to do what's called an affidavit of service that sets forth who was served, when they were served, and by what process they were served. That's the only way service is going to be valid. So choose very carefully when you pick a process server. So once your service is done, your case will proceed in one of two ways. Either the other party will respond or they won't. If the other party doesn't respond, doesn't file anything with the court in 20 days, they're in default. At this point, you can submit a default to the clerk's office. The clerk will verify that service was done, that it was done correctly, and that 20 days have passed without an answer. So, at that point, when the clerk signs off on your default, you can present the default to the judge along with a final order for your case and any other required supporting documentation, and the judge will sign off on your final orders, provided they match what you requested in your original complaint. But again, that's only if the other party doesn't respond in 20 days, so it's another exception to the rule. In the vast majority of cases, the other party will answer, and they do so by filing a document called an answer, which either agrees or disagrees with everything set forth in your complaint. It's very common for that party to also file what's called a counterclaim. That is that party's own specific request for relief from the court, what essentially they want out of the litigation. Now, once both those documents are filed, the court has both parties making their appearance on the case and participating in the litigation. It's at that point that the judge will schedule what's called a case management conference. That's a court date. Your presence is required at the case management conference, and it's devoted to just walking through the various issues that exist in your case and determining whether or not you and the other party agree on everything. If you're able to agree on everything at the case management conference, the judge could issue his final orders right there. You'll write them up, submit them to the judge, and he or she will sign off on your orders, and you'll be done without ever having to return to court again. If, however, you and your opponent disagree on one or more areas in your case, the judge has no alternative but to set the matter for trial. So trial is typically set 60 to 90 days after the case management conference, and trial is your opportunity to present all your witnesses, exhibits, and other documents that you want the judge to review before he makes his decision. It's very important to note that between the case management conference and the trial, you're going to encounter several very important deadlines that have to be adhered to, or you could seriously jeopardize your case. You have to provide all the documents you plan to use at trial to the other party. You have to list all of your witnesses and what they're expected to testify about. You have to put together a list of exhibits, and you generally have to prepare what's called a pretrial memorandum. There are very specific deadlines issued by the judge, and again, if you don't adhere to those deadlines or do it correctly, you could find yourself having problems at trial. If, for example, you don't disclose your witness list by the deadline, you may not be able to call any witnesses in your defense at the trial. So it's very important to adhere to these deadlines and be properly prepared for trial if you want things to go smoothly at trial. So when your day of trial comes around, trials are generally either set for a half day or a full day. Half day being 3 hours, full day being 6 hours. In some more complex matters, it can be set for several days, but most trials are either set for a half day or full day. You'll get half that time to provide all your exhibits and documents to the judge, to call all your witnesses and question them, and to cross-examine all the other parties' witnesses. Again, you get half the trial time and your opponent gets half the time. At the conclusion of the case, the judge will make a decision, sometimes issuing a decision directly from the bench without taking a break. Most often, however, the judge will take a break, consider things very carefully, and issue your decision. In some cases, of particularly complex cases, the judge may need additional time to either review the testimony, the exhibits, and other documents, or maybe do some research on the other case law of similar cases to yours, and he will then take the matter under advisement, which means he or she's going to take several days to consider what the decision is going to be, and will then issue a written decision regarding your case. Now, you've essentially completed things. You've filed your complaint, you set forth your issues and what you were looking for, and you've now gone to trial and the judge has made his decision. That's basically how a case moves through the family court here. I would encourage you to watch my other videos so you have an understanding of various areas of family law. In particular, I want to point you to the motions video, because motions are very common and they can result in additional court dates. There are also ways that you can get in front of the judge more quickly, or you can clean up issues after trial that weren't fully resolved. So I would encourage you to watch that. I would also encourage you to contact me for a consultation if you have a family law matter. My number is 702-425-6301, or you can find me on the web at www.lvdivorce.com. That's LV like Las Vegas, divorce.com. So good luck with your case. Hopefully this video will help you. Again, I encourage you to watch my other videos, particularly the motions video, and please contact me if I can be of further assistance. Thank you.